What if policies make indivisible rights visible to all EU citizens? What if legislation makes rules more relevant to our common values? What if this makes people the priority of our law and policy making? All by using the Charter of Fundamental Rights. Since 2009, the Charter has served as an essential tool in turning EU citizens' rights into reality. As a result, we've advanced our laws and policies as the EU has adopted many initiatives to protect and promote people's rights. But now is the time to take them even further. With over 50 articles, the Charter is a legally binding, modern human rights catalogue that enriches existing entitlements. Its profound phrasing goes beyond many constitutional texts. It can inspire law and policymakers to develop more sustainable and better legislation. And where states, regions or municipalities are acting on matters where the EU has a say, the Charter turns from a soft aspiration into hard laws to the benefits of all of us. The Charter helps you to make indivisible rights visible, rules more relevant, people the priority. Apply the Charter, deliver our rights.
Apply the Charter, deliver our rights. Exactly today, we will discuss how we can do that better. Good morning, Europe. Welcome to the virtual conference reinforcing the EU Charter Rights of People in the EU in the next decade. Our event marks exactly 20 years since the ratification of the EU Charter of Fundamental Rights, which, in line with its very name, holds fundamental importance to citizens of Europe. This event is organized by the European Union Agency for Fundamental Rights, FRA in short, in partnership with the European Commission. While my name is Karolina Zbytniewska, I am the editor-in-chief at Euractiv Poland, this event's media partner, along with Euractiv.com. I am having a pleasure and honor to chair this conference. Our distinguished panelists today are Věra Jourová, European Commission Vice President and Commissioner for Values and Transparency, Koen Lenaerts, President of the Court of Justice of the European Union, Michael O'Flaherty, Director of the European Union Agency for Fundamental Rights, and last but not least, Francisca van Dunem, Minister of Justice of Portugal, as Portugal will assume the 6-month rotating EU Council presidency on the January the 1st. 20 years after the EU Charter of Fundamental Rights has been ratified and 11 years after it has entered into force, along with the Treaty of Lisbon in 2009, we are meeting today following the European Commission's revised strategy for the Charter's implementation. Now we'll celebrate the Charter's birthday, 20th birthday, by discussing how it has been applied so far and how to reinforce its application in the next years. So we have 4 distinguished panelists, the Charter of Fundamental Importance, and no time to lose. I will therefore jump into my first questions, and I would like to start with Věra Jourová. But before I start asking my first question, I would like to ask all our distinguished panelists, while you are not speaking, please mute your microphones. So that's my kind request. Mrs. Commissioner, Mrs. Vice President, it has been 20 years, as I said, since the proclamation of the EU Charter, and over 10 years since it has been legally binding. Has the Charter had a tangible impact on the EU and its institutions over the past decade?
Thank you very much. Good morning, everybody. I am really happy to be here with you. with you, Carolina, and other distinguished panelists who I am always so happy to meet in person. So this time through the video. Well, indeed, let's celebrate the birthday of the Charter. 20 years, young lady. She should be full of strength and potential. So let's help her in the next years, in the years to come, to have, as you say, more tangible and more visible impact on the lives of the citizens of the EU, because she has been designed or born to help the people to have better life in the EU. So it is a timely moment to underline that the Charter was a milestone for the European project. With the Charter, we have made a clear shift from the EU being primarily an economic venture to a union built on shared values and fundamental rights. It is also a timely moment to underline that the Charter is not a collection of good intentions. For over 10 years now, it has been a legally binding instrument that has the same values as the EU treaties. The Court of Justice has played an instrumental role in this, clarifying the content and the presence of these rights, and I am sure President Lenaerts will most probably illustrate this in a moment. But we, as a Commission, also did our part. We put forward EU rules, quite strong EU rules, to secure and promote citizens' rights. The rules on data protection, on gender equality, on protecting whistleblowers and protecting victims of crimes are just some of them. And I would like to acknowledge here also the EU Agency for Fundamental Rights for its work. It has developed into a trusted EU body supporting our work. We rely on its data collection, surveys and reports to underpin our policy priorities. In the past years, most member states have established independent national human rights institutions to help better enforce people's rights, and it changed the human rights protection landscape. And I hope that all member states will be equipped with such an institution very soon. But there is no time for complacency. The rights and principles enshrined in the Charter are far from being a reality for all. Every day in Europe, people are victims of discrimination, hatred, and violence. The COVID-19 crisis widened the equality gap and put fundamental rights to the test, as illustrated also by Fundamental Rights Agency in its latest reports. We also see laws that limit people's rights and make the work of civil society organizations and rights defenders difficult and sometimes even impossible. And we also see an information gap. Too few Europeans know and understand their rights. For too many, they are paper promises. And this creates a fertile ground for populism and political extremism of all sorts. Also, new developments such as the digital transformation bring both new opportunities, but also, as we all know, new challenges. It is therefore time for a renewed commitment to the fundamental rights protection and enforcement. Given its full force, the Charter can really help transform people's lives. That is why the new strategy on strengthening the application of the Charter of Fundamental Rights aims for. We adopted a strategy, I think, a week ago, and we have a real plan to work with the strategy as with a rather action plan, which will deliver concrete actions. So together with my colleagues, European commissioners, we are very much determined to bring it to life. And of course, I also count on the help of all the people who are sitting now around the table and many others. Thank you very much.
Thank you very much. So only one short follow-up question. So how does this year's strategy differ from the one the Commission adopted in 2010?
I just noted why the new strategy and why now. Just over 10 years ago, when the Charter became legally binding, this meant that also EU institutions were bound by it in all their actions. The last strategy, or the previous strategy, focused on the effective application of the Charter by the EU. It looked in particular at what the Commission could do, to be beyond reproach and ensure that all its initiatives comply with the Charter. In this new strategy, we of course look at what more can be done to ensure that EU institutions comply with the Charter throughout its legislative process. And the Commission will boost its internal capacity on Charter compliance, including through e-learning, updated guidance for staff and training plans. But above all, and this is the novelty of this strategy, we want to put the focus on strengthening the application of the Charter in our member states. We want to support those who apply the Charter in their daily work. We want to help them make the Charter a reality for the people. And to name these actors who they are, on the one hand, the member states, national and local authorities, and on the other hand, civil society organizations, rights defenders, and also the judges. We also want the people to know about their Charter rights, and we want to explain them where they can turn when their rights have been breached. We want to strengthen our partnership with national and local authorities and support them in complying with the Charter when they implement EU law. This covers also the implementation of EU funds. At the start of the new budgetary period, it is important to recall that any EU-funded project must comply with the Charter. And we have taken concrete steps to help member states ensure that funds are spent in full compliance with the Charter. Further on, we will be publishing a report on the Charter annually with a stronger focus on the application of the Charter in the member states. We will select each year different thematic issue to be reported on. So for the next year, 2021, we chose the issue or the topic of the impact of digital transformation and artificial intelligence on the fundamental rights in the EU. Also, we want to support civil society organizations and what we call rights defenders. By this, I mean national human rights institutions, equality bodies, and ombudspersons. As noted, they are key players in promoting and protecting the rights enshrined in the Charter. And it cannot be only moral support. We plan also the funding support to the organizations. And also, we will look into how to strengthen their position by new rules, which might also give them maybe more potential or more powers. We will also provide more opportunities for specific Charter training for judges. Judges are absolutely key to making the Charter effective in people's lives. And we want people to know about their rights and where to turn. We will work on an awareness raising and make sure information is accessible to all, including to persons with disabilities. And the EU institutions, we cannot be excluded, rather we should be exemplary. We need to make sure that the human dimension is at the core of the EU's legislative and policy work, especially in areas like the digital transformation, the green transition, social rights, migration, and security. We will roll out actions to ensure that the protection and the promotion of Charter rights are embedded in the initial design of our initiatives and throughout their journey in the Commission. I am looking forward to cooperating with the Fundamental Rights Agency and all the key players for the Charter's enforcement that we refer to in our strategy. And of course, I have to use the opportunity of having Francisca here, Minister van Dunem, to take this work further with her under the Portuguese presidency. Thank you.
Thank you very much for this comprehensive overview. Now off to Michael O'Flaherty, Director of the European Union Agency for Fundamental Rights. What has FRA observed over the last years? Does the data and analysis provided by FRA over the last 10 years offer an evidence basis for this new European Commission strategy? Or is the Commission here simply adding one strategy after the other for political reasons? How do you see that?
Good morning. Let me begin by reiterating what the Vice President has said about the importance of the Charter. It's a groundbreaking legal instrument, and it's under-acknowledged and underused. And we know that from our work. We've been closely following the delivery of the Charter, both at the EU and member state levels for the past 8 years, publishing our findings in an annual catch-up. And what we have seen repeatedly over all that time is a growing use in the EU institutions, which is obviously very welcome, but a severe underuse at the level of member states. An underuse in terms of awareness of the Charter among the key groups, such as those that Vice President Jourová mentioned just now, lawyers, judges, but also parliamentarians, politicians, civil society, and beyond a limited awareness, also a limited application. One of the important things about the Charter is the way it engages right across the families of human rights, civil and political rights for sure, but also socioeconomic dimensions of human well-being. And that second dimension has been much underused. And so it's limited general awareness, and then to the extent there's awareness and use of the Charter, not engaging all of the subject areas. We also know from our work where the problems lie. Yes, it is about general awareness raising, but it's also about a nervousness about the application of the Charter. It's a very important instrument, but it's not an easy instrument. And so, for example, it only applies at the member state level in an area of EU competence. And not everything about our national life is in that realm. Much is. But sometimes in the grey area, it's difficult to determine whether the issue does or does not fall within, in which case the Charter would apply. And then just to take one other example, and I'll move on, we also know that there's confusion out there among legal practitioners in particular about the distinction we see in the Charter between so-called rights and principles. And depending on what category a particular bit of the Charter has, there are different legal consequences. And again, this causes some confusion. But all of this can be fixed. And that's why we welcome the Charter so much. This is a smart strategy, excuse me. This is a smart strategy, and we really want to acknowledge the Commission's work here. For example, the strong focus on the national level, the level of member states in this new strategy is very welcome, because that's where the big problem is. And secondly, and I'll stop with this, the underuse of the Charter across subject areas is also acknowledged in this strategy in the way in which it demands a mainstreamed approach. And so we look forward to working with the strategy. We think it's a valuable contribution. It's certainly not just one more strategy. It's a once-in-a-decade tool to make a serious push for this such an important instrument. Thank you.
Thank you. We just wanted to make sure. Is the Charter a real human rights convention, or is it rather the modest result of a European Union that is mimicking the member states without having competences to offer full human rights protection? Another controversial question.
Wow, I was going to say, what a provocative question. How could I agree with that? To the contrary, in the first place, this instrument is globally significant. It embraces all human rights. When it applies, I come back to this issue of EU competency, it can hit in a way no human rights treaty can hit at the national level. It can have direct effect. You can invoke it in your courtrooms. You can invoke it before the state. It sometimes even has effect between citizens, which again is a very distinctive feature of this instrument. It's the guarantor of the Europe of values. You know, we talk so much about the Europe of values. Where's the evidence for that? Well, the legal evidence is the Charter of Fundamental Rights. It's the legally binding guarantor that our union is not primarily about economics or about money or things of that nature. It's about human dignity. And this brings us right back to the whole reason the EU was founded. And so it's a contemporary reminder, which isn't just a gentle reminder, but is a legally binding one, a compelling one. So no, this is an important contribution, under-acknowledged, I'll admit that. And certainly outside the EU, the groundbreaking nature of this instrument needs to be better understood and better appreciated, but absolutely invaluable.
Thank you for these very important words. Now off to Koen Lenaerts, President of the Court of Justice of the European Union. Fundamental rights are for 4 decades part and parcel of the case law of the Court of Justice of the European Union that you preside over. So what is that the Charter has added to the EU's judiciary over the last 10 years?
Well, before answering that question, I would first like to say that I'm very grateful to the organizers for having invited me to participate in this event, marking the 20th anniversary of the proclamation of the Charter of Fundamental Rights of the European Union. I would like to congratulate them for this wonderful initiative that seeks to raise awareness. That's what's important now, of the positive impact that the Charter has had and will continue to have in our daily lives as citizens of the EU. I'm of course honored as well to chair this panel with distinguished colleagues such as Vice President Jourová, Minister van Dunem, and Director O'Flaherty. It's a pleasure to discuss alongside them in this panel. But let's focus on my task as a judge and president of the Court of Justice of the European Union. And there I can observe, first of all, that the Charter has had an impact on both our workload and our case law. Quantitatively, the Charter has increased the frequency with which fundamental rights issues are raised before the Court of Justice. Indeed, as a formal written document, it has given greater visibility to fundamental rights in the EU legal order. That enhanced visibility has enabled judges from the 4 corners of the EU to become better acquainted with the EU system of fundamental rights protection. Today, approximately 15% of the cases brought before the Court of Justice concern the interpretation of the Charter. A quick search in the internal database of the Court of Justice shows that out of the 865 cases settled in 2019, 135 involve the interpretation of one or more provisions of the Charter. Qualitatively, the Charter has brought the Court of Justice and national courts closer to the EU citizens, since every case involving a fundamental right recognized by the Charter calls upon judges to protect those rights against unjustified limitations on their exercise. This often involves engaging in a balancing exercise between individual liberty and the common good. The Charter has therefore strengthened the role of judges as guardians of democracy, liberty, and justice in the EU legal order, since judges are called upon to provide effective judicial protection of the rights that EU law confers on individuals, including those recognized by the Charter. In cases brought before them in which EU law applies, judges may, for example, rely on the Charter in order to prevent individuals from suffering discrimination simply because they have a different skin color, believe in a different God, or love a person of the same sex. In the same way, judges may rely on the Charter in order to prevent public authorities from acting as an Orwellian big brother who watches over everything that we do online and offline. Similarly, judges may rely on the Charter in order to ensure that any third country national who arrives to Europe seeking to escape the ravages of war and persecution is treated with the dignity and respect that every human being deserves. That said, the Charter does not seek to replace the catalogues of fundamental rights laid down in the constitutions of the member states. Nor does the Court of Justice seek to become a second European Court of Human Rights. On the contrary, when it comes to the member states, the application of the Charter is limited by the principle of conferral of competences to the Union. Unlike national constitutions and the European Convention of Human Rights, the Charter is not self-standing, but, to put it metaphorically, it is the shadow of EU law. Just as an object defines the contours of its shadow, so the scope of EU law determines that of the Charter. Since the protection of fundamental rights in Europe is governed by a plurality of sources, the Court of Justice has had recourse to the Charter in order to pave the way for a harmonious relationship between the Charter, national constitutions, and the European Convention on Human Rights. In that regard, the Court of Justice has held that higher national standards of fundamental rights protection may apply in the absence of EU measures harmonizing such standards. This means, in essence, that it is for the EU political institutions, whose operation is based on the principle of representative democracy, to decide whether national standards of fundamental rights protection are to be replaced by a uniform standard at EU level. That said, regardless of whether the EU political process chooses diversity over uniformity or vice versa, the Charter must always be complied with when EU law applies. In the same way, the Court of Justice has held that rights recognized by the European Convention on Human Rights, corresponding to those guaranteed by the Charter, constitute a minimal threshold of protection that does not prevent EU law, and more particularly the Charter, from adopting a higher level of protection. Examples where EU law has followed its own autonomous path of a higher protection of fundamental rights can be found in two recent judgments of the Court of Justice, one concerning the principle of ne bis in idem, the other relating to the notion of detention in respect of asylum seekers. This brings me to my last point. Judges can be the guardians of democracy, liberty, and justice if, and only if, they provide citizens with effective judicial protection. However, such protection may only be provided by courts that are independent and sufficiently robust to stand up to the political majority of the moment. Strong, independent courts are the backbone of the rule of law within the EU, part and parcel of which is the protection of fundamental rights. That is why the Court of Justice has ruled on a number of occasions that EU law protects the independence of national courts. Thank you.
Thank you very much, President Lenaerts, for these examples of really tangible application of the Charter. Now off to Francisca van Dunem, Minister of Justice of Portugal. Mrs. Minister, I am interested in the EU member state perspective. What was Portugal's experience over the last 20 years with the Charter in the three branches of government: administration, legislation, and judiciary?
Muito obrigada. Bom dia.
Thank you very much. Good morning, Catarina. Good morning, Vice President of the European Commission, the President of the Court of Justice of the European Union, the Director of the European Union Agency for Fundamental Rights. Thank you very much for the invitation to take part in this event. It's an honor for me to participate in this event in my capacity as Minister of Justice of the member state that will hold the next presidency of the Council. Allow me also to congratulate the European Commission on the presentation of the new strategy, which seeks to fully implement the Charter of Fundamental Rights. As it was said today, the entry into force of the Treaty of Lisbon marked the culmination of a long process of humanization of the European Union, from a largely economic project to a project centered on the human person. This fundamental change in the legal nature of the Charter determined the consolidation of the EU legal framework on the protection of fundamental rights. And the Charter became then a benchmark for the Union's law and actions of the subjects in this legal framework, including, first and foremost, the Member States when they apply the EU law. The respect of the fundamental rights and mutual trust might be affected in important areas such as the space of freedom, security and justice, the non-discrimination, the citizenship of the Union, and the information society. Now, regarding your question, Carolina, well, the Portuguese experience, in our opinion, appears to be in line with the experiences of all member states in general. It shows that despite the recognition of the added value of the Charter, its degree of application is still short of its potential. A possible explanation for this reality might be related to the Constitution of the Portuguese Republic, which dates back to 1976, that put an end to the dictatorship. Although it's a lot older than the Charter itself, the Constitution, the Portuguese Constitution, incorporates a very comprehensive set of fundamental rights, including virtually all the rights enshrined in the Charter. This coincidence means that the respect of the rights provided for in the text of the Charter is largely and materially guaranteed in the Portuguese law through the Portuguese Constitution. And this, to a certain extent, explains why only seldom the Portuguese law practitioners and courts invoke and directly apply the Charter. However, I can say that more recently, there have been signs that this reality is gradually changing. Regarding the judiciary, there is a growing trend to resort to the Charter as an aid to construct the law by the Constitutional Court. Due to its importance, I would like to highlight a recent ruling by the Portuguese Constitutional Court, a ruling which fostered a wide discussion amongst academics and legal practitioners. The ruling reaffirms the principle of the primacy of the EU law, as well as the exclusive jurisdiction of the European Court of Justice to assess the validity of the rules of the EU law. This, therefore, implies that the national constitutional courts should refrain from carrying out their constitutional duties in that specific domain. The role of the Charter in the European legal system is also underlined in this ruling. And the same has been observed in the Supreme Court of Justice and higher courts in Portugal when they apply national laws that transpose the union law into the domestic legal system. This has been observed in recent years with the application of rules that give expression to the principle of mutual recognition in criminal matters, like the European arrest warrant. These decisions/rulings increasingly refer to the Charter and the case law of the European Court of Justice. Regarding the training of legal practitioners, I must say that the training plans of magistrates and lawyers include content on fundamental rights and European law, and obviously content about the Charter. The training of judges and lawyers is very practical in the form of seminars or conferences on very specific topics. It should also be noted that the Portuguese School of Magistrates publishes on a regular basis a newsletter about the case law of the Court of Justice while providing training on that matter as well. The universities, and in particular the School of Law, play a very relevant role in this context, including the Charter in their curriculum. Recently, the academia has been promoting the Charter more proactively with initiatives targeted at the public in general or more specific to lawyers. And I would like to highlight the project entitled The Charter of Fundamental Rights of the European Union in Action, a project financed by the European Commission and developed by a consortium of European universities, in the context of which several training sessions and conferences were organized in 2018, which led to the development of a manual of best practices and a training manual. The Ministry of Justice has been promoting the awareness and application of the Charter through the dissemination of relevant information in our institutional websites and by disseminating the tools offered by the European Union Agency for Fundamental Rights and by the Commission. This year, we have planned a training course in cooperation with the Fundamental Rights Agency, which unfortunately had to be cancelled due to the pandemic. In any case, we would like to take this opportunity to thank FRA for the availability. The objective of this training was to address the shortcomings identified regarding the training of the actors of the legislative process who have been more neglected in this context. We have also been busy in implementing the Charter within the scope of the European funds. To this end, the Ministry of Justice has sought to design tools and provide training to help ensuring that the relevant programs comply with the Charter. The dialogue established with the Agency for the Fundamental Rights on this topic has been very fruitful and relevant. But despite the above-mentioned efforts, it is true that the law practitioners are relatively unaware of the added relevance and applicability of the Charter, a fact which also extends to the Portuguese citizens in general. In conclusion, at the national level, Portugal acknowledges that there is some way to go and commits itself to continue working to ensure that the Charter is deeply rooted in the Portuguese legal and civic culture. To this end, the guidance resulting from the strategy of the Commission will be very relevant, of course.
Thank you very much for bringing up this very particular perspective of one of the member states of Portugal. Now it's time for a short break before the panel discussion. We'll see a film about the Charter that takes exactly 2 minutes, 57 seconds. Please watch it with us and see you in a bit.
As the fields of science advance, human dignity must remain in the spotlight, safeguarding our physical and mental integrity. The Charter explicitly promotes these values, including protection against human trafficking. The Charter provides a list of entitlements surrounding people's freedoms, with distinct definitions for a sound understanding of our fundamental rights, including the right to asylum and the protection of personal data. More explicitly addressing the full spectrum of discrimination, the Charter better promotes equality and diversity regardless of sex, ethnicity, religion or sexual orientation, emphasizing the rights of children and the elderly, as well as requiring the integration of persons with disabilities. The Charter underlines the importance of solidarity and socio-economic rights and principles ranging from safeguarding our family and professional lives to consumer and environmental protection. The Charter brings to light opportunities for participating in and being protected by the EU legal and political system. This includes the right to good administration and the freedom of movement and residence within the EU. Going beyond the existing European standards in procedural law, the Charter addresses the right to a fair trial in all possible processes, including administrative, tax or asylum procedures.
Sorry, I was muted. So again, in the film, we've received some concrete instances of where the Charter offers us support. So now is the high time for the panel discussion. I will oversee the flow of our talk with questions, but please feel free to answer and comment on each other's words, all right? One thing that I would like to ask you for is, however, to confine your replies in 3 minutes each, please. Commissioner President Věra Jourová, please tell us, how about the people in the Charter? Either if you are a member of the majority or a minority or a victim, or if you belong to a vulnerable group such as Roma, asylum seekers, LGBTQI+, how can the Charter help the people of Europe, and how does the strategy add new possibilities here? President Jourová, please unmute yourself.
And you were deprived of very interesting start. Sorry.
Please don't deprive me of that.
Up to now, we spoke about the Charter as a horizontal, legally binding tool or instrument, which is in fact covering the EU values. So for me, as the Commissioner or Vice President for Values, you can imagine that this is the main legal instrument I work with. But we need to do everything the people can enjoy the rights which are enshrined in the Charter. So inevitably, we have to work also on different pieces of work which cover the issues relating to the vulnerable groups which you mentioned. We decided in the Commission to accelerate the work, because you can imagine the COVID-19 suddenly brought about other needs and big policies and the money to be delivered, the recovery money and so on, many big important things. And we said, what is bigger than the fundamental rights? And that's why we decided to keep all other initiatives in the work program for this year. So we already adopted the strategy for LGBTIQ citizens, Roma and ethnic Roma strategy, also strategy for gender equality. And you might oppose that, again, I speak about the paperwork, about the strategies rather than something real. But we have to understand that the strategies which we adopt then follow the destiny ending up on the tables of the ministers, of the statesmen. We always want the council to adopt the conclusions, to recognize the importance of the actions which are foreseen in the strategies. And at the same time, and this is my specialty here, I, as somebody who came to the Commission from the world of EU funding, I always insist that in the EU strategies, we have to indicate where the funding will be for the projects which will help the people. I don't believe that all the magic lays in the finance, but the finance is important. Without that, the strategies might be just the paperwork and lip service, if you want. But also other things which stem from these specific strategies should be mentioned here. We already announced that for the next year we want to extend the list of Eurocrimes to cover also for hate speech and hate crime, including homophobic hate crime and hate speech. So this will be a piece of legislation I will be fighting for a lot, because every time we come with the proposal to legislate in the field of criminal justice, it is confronted with quite strong, sometimes pushback from the member states, because this is a very sensitive part of our shared competencies. But we need to open the way to adopt the European legislation banning homophobic hate crime and hate speech, especially online, because also, Mr. President Lenaerts spoke about that. We now live in new reality by also seeing that the impact of everything what's going on in digital world has a very strong impact on our real life. Also, we want to improve or propose the new legislation on mutual recognition of child-parent relationship across the borders in the EU. I was meant to speak 3 minutes, yes, so I should stop
Yes.
now. So I will skip the description of this new legal status recognition because you will follow our work, I'm sure, next year when we will come with this legislation. And there are some other concrete examples where we will in fact follow what's foreseen in all those mentioned strategies. So no surprises, just steady way forward.
Thank you very much. Just a steady way forward. So off to Michael Flaherty. I would like to ask you how FRA will complement the Commission's plans, providing expertise and capacity building.
Thank you. Yes, just before I get to that, allow me though to express appreciation for the great interventions we've been hearing this morning. And I just wanted to pick up on a couple of points. I really appreciated what President Lenaerts has said to us. And for example, his focus on the role of judges at the national level. And listening to him, it occurred to me that we have to acknowledge those moments when national courts are champions of the Charter. And draw attention to that to, in a sense, encourage all other courts. I think, for example, of the German Constitutional Court, which repeatedly has done very impressive work in applying the Charter at the national level. Turning just for one moment to Minister Van Dunem and to Vice President Jourová, who both addressed the issue of Charter conditionality for the disbursement of EU funds. And I think this is so important. It, in a way, has to be perhaps the headline of our discussions today. It's not only a recognition of mainstreaming of the Charter across all dimensions of EU life, but also, of course, it's a critical, it would be a critical advance in strengthening the enforcement capacity. And a law without enforcement isn't a law that's brought fully alive. So I just want to welcome those. Now, what will we do? Let me first be very specific. The Commission is going to produce annual reports starting in 2021 on the Charter and its application. We'll support that in every way that we possibly can. The Commission has told us that in 2021, the topic will be the Charter in the digital age. I mean, it's a great topic, and we'll support that with our evidence and our data, but also our research, because the work we do on artificial intelligence, on the use of the internet, is directly related. So we'll bring the full capacity of the agency to bear. We'll reach out to the national Charter focal points when they're appointed, and we'll give them all appropriate support. We'll intensify our program of capacity building, which we do with partners, such as the European Judicial Training Network. We already invest in and will continue to invest in strengthening and supporting the national human rights, fundamental rights infrastructure, civil society, national human rights institutions, equality bodies. And of course, we'll continue to develop e-tools, which in fact, there'll be a presentation of our e-tools later this morning following this event. And we'll continue to invest there as well. At the institutional level of the EU, we're also deeply engaged, both with specific parts, such as other agencies, but also with the Commission, the Parliament and the Council. We, for example, do charter training with presidencies of the Council, which we'll certainly continue to offer. And last but not least, because my time is short, we have an every 3 years event called the Fundamental Rights Forum, which takes place in Vienna, biggest event of its kind periodically in Europe. And the Charter always has been, but will continue to be the golden thread running through every dimension of the activities of the forum. Thank you.
Thank you very much. So now after Koen Lenaerts, your court has handed down judgments establishing that certain charter rights, like for example, the right to a fair compensation or the Article 21st, which protects against discrimination, could apply horizontally so that they can oblige private parties like employers to provide, for example, paid annual leave. Is there a risk, in your view, that the Charter establishes direct horizontal obligations that were not literally intended by the Charter's authors?
Well, I wouldn't speak in that respect about a risk. It is true that when you read Article 51, first paragraph of the Charter is primarily addressed to the institutions and bodies of the Union itself, and to the member states, as was already mentioned, exclusively when they implement Union law. So at first blush, this may lead to the conclusion the only addressees as bearers of obligations are Union institutions and bodies, and member states, public authorities, whenever they act within the realm, within the ambit of Union law. However, the Charter needs to be interpreted in conformity with the constitutional traditions common to the member states. That is mentioned as one of the guiding principles of interpretation of the Charter, mentioned in Article 52 of the Charter. Now, when you look at these constitutional traditions of the member states feeding in the interpretation of the Charter, a number of fundamental rights are being enforced by the constitutional courts of the member states in a horizontal relationship. Not all the fundamental rights, but those fundamental rights which are mandatory in content, that is, fundamental rights which do not need any further implementation for their enforcement, that is, fundamental rights which are plain as such on the one hand, and on the other hand, fundamental rights whose very content depends on other private parties respecting them. So it's these two conditions. That is why it's only a very limited number of fundamental rights contained in the Charter, which the court has, on a case-by-case basis, declared horizontally applicable. You mentioned one, Carolina, namely the Article 21. That is the principle of non-discrimination. Non-discrimination on grounds of race, ethnic origin, religion, sexual orientation, age, and so on. It is applicable as such. And if this is specified in the employment relationship, which is one of the directives having harmonized the fundamental rights standards in that field, it's quite clear that you would deprive that fundamental right of any meaning if a private employer were not obliged by these non-discrimination grounds vis-à-vis, obviously, a private worker. So that's a good example. The very essence of the right can only be guaranteed when it also applies between private parties, because to the right of one party, corresponds the obligation of another party. The same applies for the annual leave protection. It would not make sense to say only public employers need to respect the annual leave because they're an emanation of the state and somehow we are in a vertical relationship. No, I mean, public employers, private employers are to the same effect, are in the same situation in terms of bearers of obligations. So that is why the court cautiously proceeds in line with the constitutional traditions of the member states in respect of the horizontal application of the Charter. It's what in German constitutional law is called Drittwirkung der Grundrechte. So this is totally in line with that Europe-wide tradition.
Thank you. So indeed, it's not a risk, but rather an advantage. Okay, so off to Minister Francisca van Dunem. Portugal, as I mentioned in the beginning, is assuming the presidency in the EU Council in just about 3 weeks. What are the plans during the Portuguese presidency to advance the implementation of the strategy in the Council? European Commission invites the Council to adopt follow-up conclusions on the strategy. What is your ambition here? Will we, for instance, see a commitment to an annual charter review in the Council?
Thank you, Carolina. I'm sorry. I mentioned Catarina the other time. Now, Carolina. Let me answer in Portuguese. A intenção da presidência portuguesa.
During its presidency, Portugal will focus on two large topics in the field of justice. On one hand, the protection of vulnerable adults, whose need for protection was further emphasized by the COVID-19 pandemic, and on the other hand, the digitization of the justice, which brings undeniable advantages for the realization of the rights enshrined in the Charter, including the right of access to justice, but on the other hand, may have adverse impacts on the exercise of those rights, which are important to consider carefully and address appropriately. Regarding our presidency, our ambition is to begin the effective implementation of the new strategy. This will be at the top of our agenda. Taking into account the fundamental role played by the member states in this matter and answering to the call of the Commission, it is our intention to adopt conclusions of the Council that cover the various dimensions of the application of the Charter in the member states contemplated in this new strategy. In this context, attention must be paid to the existing shortcomings, but also to the new challenges stemming from the current reality, particularly in the fight against terrorism and organized crime, the fight against hate speech, racism, xenophobia, discrimination, cybercrime, victims' protection, particularly the most vulnerable victims, women and children, and also access to justice. These are all aspects within the objectives and priorities of the Portuguese presidency, and we will do all we can to achieve them. The annual exchange of views is a very interesting idea. In fact, annual exchange of views is already usual practice in the Council preparatory bodies following the presentation of the Fundamental Rights Agency annual report and following the Commission's report on the application of the Charter. To expand this discussion to the ministerial level could be one path to explore in view to increase the visibility of the Charter and the corresponding implementation efforts at the national level. We are certain that the discussion with the experts on fundamental rights from the various member states will lead to many other interesting proposals, and we are committed and, of course, ready to work hard on this issue.
Thank you very much. I wish you good luck, because your good luck will be the good luck of all member states and European citizens in that instance. Here's how we end the short panel discussion. Now, before I go to the Q&A session, just 3 important quotes with feedback on the Charter and its implementation. The first one quite critical, as you will see, and 2 very constructive ones. Please listen closely as I will read them out, and I hope for some return feedback from our panelists in the Q&A session in a minute. So last year, on the occasion of the conference celebrating the 10th anniversary of the implementation of the Charter, one judge commented as follows: "I find the Charter complicated to understand, rather unclearly drafted, and difficult to implement in my daily decisions. If you allow me to be frank, I currently do not consider this text as being successful, and I have serious doubts about its utility for a day-to-day practice." One member of the civil society commented that European Commission should take a much stronger role in holding states to genuinely discharging their duties under the partnership principle, formally requiring states to establish independent platforms for monitoring the application of the Charter. Finally, one local authority representative in a way followed up on the previous comment and on the topic of cooperation platforms for better implementation of the Charter. Platforms should be set up to enable local and regional administrations to exchange experience and best practice. So our panelists received some food for thought and for work maybe too, especially as regards enhancing the creation of the cooperation platforms. But in the meantime, let's turn to the third part of our webinar, to the Q&A session. We have received literally loads of questions from our guests today, and I will read out some of them and appropriate them to one panelist each. Now again, I would like to ask you for really short answers, now even shorter than recently, maybe 2 minutes long. Thank you in advance. So first off to Věra Jourová. We've received numerous questions concerning the epidemic of systemic homophobia in Poland. I will read just 2 of them, both by civil society representatives. First one: "I've been living in Poland for all my life, and I was hopeful that one day LGBTI+ rights will be a reality here. But it's getting worse and worse. How is it possible that LGBT-free zones are legal? It's outrageous, and you as a vice president of the EC have to do everything you can to change it. Please start infringement procedure on the basis of the LGBTQ-free zones." And the second: "I'm Gay's mother. The atmosphere around LGBT people is deteriorating. We started feeling like Jews in the 30s in Germany and consider leaving the country with the family. We are waiting for the EU to take care of us, for we are EU citizens. We are waiting for you to undertake the decisive actions. We want to be safe and respected in our country." So both questions are a call for answer and for action. What is your answer, Mrs. Vice President, to these voices of despair shared by many, not only in Poland?
Yes, thank you very much for the question relating to really very painful problem, and I am in my thoughts with the LGBTIQ people in Poland and their families, because the mother who wrote the question, of course, she wants to have a good life for her son or a daughter. I forgot the concrete case. have said many times that the LGBT free zones are humanity free zones, and they have no place in the union being LGBTIQ or being the union of equality. And I was really shocked by the declarations that LGBTIQ people are not people but ideology from the highest possible political places. So we are watching the situation. We already finished the financing of some of the projects from these zones. We are watching the situation, the development in the field of legislation, because the LGBT zones, free zones, were not set by the law. If it was in the law, we would immediately start infringement procedure. But these were declarations by the municipalities. So, but we are still discussing whether there might be a chance to address the issue with the legal instrument. In the meantime, we are looking more on the financing. It was a surprise for many when I said at the press conference that we have for the cohesion policy this enabling condition that the money will only go to the projects which are in full compliance with the charter. It was surprise for many, in spite of the fact that this conditionality is there for maybe decade or more. Yeah. So now we show clearly that we mean it, that we will require the application of the charter. So this is from my side for the moment. You asked me to be short, but we will act whenever we see that there is a legal possibility to address the laws in Poland.
Yes, the problem with conditionality is that sometimes instead of punishing the authorities that are to be blamed, in a way, indirectly, is the citizens who are deprived from the funds. So that's one drawback. I have a question to Director of Laherty. Actually, two questions. One mine, a very, very short, and one, and wishing for a very short answer, because you said that there exists severe under-awareness in the member states and under application of the charter, but that can be fixed. Can you, just so that we all understand and have concrete advice, recommendations, understand how to fix it?
Sure. Training and awareness raising among the key professionals, that's critical. We don't need to co-equally build awareness right across society at the same moment. Right now, I would be of the view that the primary target audience should be judges, lawyers, and decision makers. And then we can filter across to the others. But we can build awareness. We can build confidence in the application of the Charter. We've developed any amount of tools to help a lawyer, for instance, understand whether an issue engages the EU competency or not. And by bringing awareness of these tools, building up knowledge of how to apply them and use them, then we're filling exactly the gap that you've just mentioned. We also will continue to invest in working with civil society so that it is part of the loud voice demanding and indeed invoking the Charter in its own work.
Thank you. So now the second question that I mentioned, it's from the legal expert. It's quite long, but also informative for our viewers. In the last 3 years, we witnessed an increasing number of cases decided by the Court of Justice of the European Union and affirming the values enshrined in the Charter. However, judgments are not followed by positive developments at the level of member states. The refusal of the Romanian authorities to recognize a same-sex marriage legally entered into by a Romanian-American family is just one example of the disconnect. The question is, how can we make sure that the positive developments in the jurisprudence of the Luxembourg Court go beyond the academic or expert circles, as we are having here now, and permeate the legal to the legal profession as well as to the decision makers. What kind of measures can be taken, mainly by the Commission, but also by FRA, to foster the interinstitutional dialogue on rights of as fundamental values?
Well, in a way, my answer would be the same as the answer to your last question. I'm in no position to speak for the Commission or indeed for the Court. So I'll just speak about our agency. Our agency plays a critical role, not just in all that training and awareness raising I mentioned, but also in gathering and sharing good and promising practices. And we'll continue to do that. If there's a strategy to promote the use of the Charter in a given topic in a given country, let's make sure that that's available to the relevant professionals elsewhere in the EU so that we can mutually draw on them. But let's invest also in having strong, vigorous civil society. Civil society in Europe is under pressure in many different ways. And we need vibrant human rights organizations, as well as all the other bits of civil society, to stand up for fundamental rights based on the Charter. So that's not a separate issue. It's absolutely central to our discussion today, as is investing in strong national human rights institutions, commissions, ombudsmen. They're not peripheral, they're central to building what I would call the culture of respect for fundamental rights that we're all aiming towards.
Thank you very much.
Could I also say, sorry,
yes.
You asked us to speak to some of those comments you had earlier,
yes.
including that very provocative comment from the judge. Let me just start by saying I disagree with him. And then I would say, let's keep in mind what the role of the Charter is. President Lenaerts was very clear on it. It's a complementary tool in a toolbox, all with the shared purpose of upholding human dignity. And if we keep that end point in mind, then the complication of using the instrument, the lack of clarity on occasion, is not a reason to put it aside. It's rather a reason to get ever more concentrated in using it smartly. Keep in mind in this regard, in terms of the complementary toolbox, that some rights in the Charter are not found anywhere else. You find much more stringent due process of justice provisions in the Charter than you do in the other human rights treaties. You find the right to establish a business, very strong rights of older people, environment rights. And are we going to just put those aside because it's difficult to work with the Charter? I think that would be far too low a level of ambition. Thank you.
Thank you very much. President Lenaerts, first, what guarantee do we have this time that this EU Charter will eradicate the injustices that have been talked about for decades, especially with regard to people of African descent, asks a representative of civil society? And if you want also to comment on Director of Lenaerts said. Please be welcome.
Thank you. Let me first start by the latter part of your question. I fully agree with Director O'Flaherty. We should indeed raise the level of our ambition. And to my colleague Judge, who made the critical comment, I would say the following. The Charter applies whenever union law applies. If there are questions about the correct understanding or interpretation of the Charter. For instance, in relation, as Director O'Flaherty gave the example of environmental protection rights, and the judge considered that to be rather difficult provisions. That is why there is the procedure of a reference for a preliminary ruling of our court to clarify those rights. So the Charter, like any other legal instrument of union law, is the object of preliminary references made by national judges to our court. When I spoke about almost 200 cases last year in which an interpretation of an aspect of the Charter played a decisive role in the construction interpretation of union law as such, it's because national judges like the one who made this comment having the courage to refer the matter to our court by way of a reference for a preliminary ruling and we clarify the charter. That is how the law progresses. Now, the charter is far more effective than you think. You quoted this Koen-Hamilton case about LGBTIQ rights. The Koen-Hamilton case, Romanian and US national homosexual couple lawfully married in the Kingdom of Belgium, and then going back to Romania. I may take issue with the fact that nothing changes there, because frankly, this couple got also for the US national a right of residence in Romania, and that was the primary focus of the case. Of course, a judge can only do what a judge can do, that is decide the litigation pending before her or him. But it has a knock-on effect that the political process starts from there. So the Koen-Hamilton married couple was recognized as a married couple in that case in Romania. Then it is a matter for the political process in Romania to see how possible unequal treatment between that couple, who was protected by union law, and Romanian homosexual couples will be eliminated, either through law or through case law, etc. So it's always a stepstone in a further process. And that also applies to your example of the African asylum seekers, for instance. They can, of course, not be protected by our case law in a proactive sense. That is what the political process needs to do. There you've rather to turn on the European Commission making proposals, which will then be deliberated by the Council and the European Parliament in the ordinary legislative procedure of the Union. What a court can do is when national courts ask us what the minimum rights are under the qualification directive for asylum seekers, how that directive is to be interpreted in compliance with the human dignity provisions of the Charter of Fundamental Rights. That is what we did in a landmark judgment of the 14th of May 2020. A Hungarian long name of a case, Országos, and then many more words, where we held, and I'm very proud to mention this, in the grand chamber of our court, that the two so-called transit zones in Tompa and in Raška are detention zones contrary to the Charter. The Hungarian government has dismantled these zones after our judgment of the 14th of May. And what is important is that our court marked it as detention zones contrary to the Charter at a time where the European Court for Human Rights, which had equally been seized of the same problem a few months earlier, had said that there was no problem under the European Convention on Human Rights. So a clearer example, precisely in the field, Carolina, of what you said, the African asylum seekers, you see how the Charter triggered a way higher protection and led to the dismantling of these zones, which were a real threat for human dignity, whereas the 17 judges strong Grand Chamber of the Human Rights Court in Strasbourg, in the Iliad and Ahmed case, did not consider this to be contrary to the ECHR, a clearer example of where the Charter of Fundamental Rights gives promises of a higher level of protection vis-à-vis the one which previously existed in Europe cannot be given.
Thank you very much, Judge, for helping us understand the importance of the Charter. Now off to Francisca van Dunem. A question from the civil society. What is the key factor of success to the implementation of the Charter in your view? What should other countries like Italy or Spain learn from the Portuguese example?
Muito obrigada. Eu penso que a questão-chave.
Thank you very much. I think that the key factor for the implementation of the strategy is to raise the awareness, information, and knowledge. The joint work carried out by EU institutions and member states in order to improve the knowledge that the citizens have about the Charter and their human rights and fundamental rights. I'm a bit surprised with that comment by the judge. I was a judge myself for many years, and as a judge, I applied the Portuguese constitution. And regarding the fundamental rights, the Portuguese constitution is very similar to the Charter. The Charter refers to specific and simple things such as freedom, liberty, equality, solidarity, citizenship, and justice. I don't see how complex can be these principles. The only thing that we must do is to put himself in the shoes of the third person, of the other one, and then we'll be able to fully implement the principles of the Charter. Portugal, like other European southern countries, including Spain and Italy, we have common features that result from our geographical location, but also our common/shared history. But I would say that the southern countries' features don't mean that the Charter will have to be applied differently here and elsewhere, because the principles enshrined in the Charter are universal principles that should be applied with the same level of effectiveness and efficiency anywhere. So, having said that, I don't think that there's a difference between what is done in Southern European countries, in other European countries, or in the rest of the world. But your question is important because we must be fully committed. We all must be committed in the implementation of the Charter, particularly in light of the current circumstances. The principles that we took for granted and that led to the construction of the European Union as this space of freedom and solidarity are now being challenged and at risk. Now it's the time to deepen the principles of the Charter. Now it's the time to move together ahead. The European Union, the Commission, the FRA, the several agencies, and the member states, so that this Charter is indeed a reality in our countries, and so that the Charter can be a living tool across all the entire European Union space, so that we can be a role model to the world.
Thank you very much. Indeed, fundamental rights cannot be taken for granted ever. Now I have 3 more questions for the Q&A, and I have one sentence question to ask to all of you, so that now I really ask you for 30 seconds answers. The first from the live Q&A is for Commissioner Věra Jourová. And it is as follows. The Charter implementation is a tool for changing the EU character, but the European Convention on Human Rights is still not signed by the EU. Is it not a worrying signal?
The negotiations are ongoing. We are making progress. We have to do everything to come with a solution which will comply with the previous decision of the European Court of Justice. So we are on the right way, and the intention is still very strong.
Thank you very much, also for keeping to the time. Now the question from live Q&A to Director O'Flaherty. In light of the protection granted to national minorities within the framework of the Charter, how does FRA intend to further uphold the rights of minorities?
The agency, I think, has been defined since its establishment in the way in which it does research, gathers data, comparable evidence in support of minorities in our societies. Our societies are only as good as the welcome they give, the respect they show for minorities within the community. So we'll stay fully focused on that. We have the migrant surveys, the surveys regarding the situation of Jews in our society. You spoke about LGBTI earlier. By the way, I want to endorse absolutely everything that Vice President Jourová said on that point. And we will continue to stay focused. We have not historically devoted a lot of attention to the specific issue of national minorities. And that's in part because we don't want to overlap with the Council of Europe. Or indeed with the OSCE, which do very important work in that area. But to the extent that we can bring value added and be complementary to the other great institutions of Europe, we'll continue to stay very focused.
Thank you very much. Another question to President Koen Lenaerts. Do you see it necessary to reinforce mechanisms that ensure the application of the Court of Justice of the EU rulings by national courts, especially when seeking to guarantee the protection of fundamental rights in the EU?
Well, a court as such has no power to enforce its own judgments. In the European treaties, it is the task of the European Commission, so I look in the direction of Vice President Jourová, to see to it that the member states comply with our judgments. If they don't do that, also in the field of respecting the Charter of Fundamental Rights, it is up to the Commission to take the initiative to bring infringement proceedings against the member states. And then the court will rule on these infringement proceedings. If an infringement is being found, there can be, in case of continued non-compliance, there can be a second infringement proceeding which leads to financial sanctions, which may be very important. So that is the mechanism for enforcement, and it applies to union law in general, and also to the Charter, the enforcement of the Charter of Fundamental Rights.
Thank you very much. Now up to Francisca van Dunem. Also, please, 1 minute or less. As we heard, the new strategy of enhancing the Charter is a call for more engagement on the side of the member states. Are the member states ready, in your view, to accept this challenge and to increase their co-ownership over this common human rights bill?
As conclusões do Conselho adotadas
the conclusions of the Council adopted last year regarding the binding nature of the Charter made very clear that the member states acknowledged the relevance of this instrument. So we truly believe that currently all member states are aware that we need to respect the Charter and to take initiatives at the domestic level in order to strengthen the youth and knowledge about the Charter. And we are ready to work with the other member states during the Portuguese presidency in order to make this a reality. Well, given the work done already on this matter, maybe what we are missing is just further guidance and dialogue so that we can deliver better results. And this is what we'll do during the Portuguese presidency.
Thank you very much. As we almost got to the end, one final question, because we need to stick to the title of our conference, which is, just to remind all of you, reinforcing the EU Charter rights of people in the EU in the next decade. So now I would like to ask each of you for just one sentence for a closing. What is the perspective concerning the EU Charter for the next 10 years, starting from Commissioner Vice President Věra Jourová?
In one sentence, it will be uneasy, but I really am very determined to prepare a good perspective for the Charter and application so that it helps the people. And it will be especially important after COVID crisis to guarantee that the vulnerable ones will not pay the price for COVID. And I mean also under the vulnerable ones group, the single mothers, all the people who already before COVID were under the line of poverty, the people who are facing different kinds of discrimination. This will be the moment of truth. So hopefully Europe will do everything in the way that the COVID crisis will not create a bigger level of inequality in the EU.
Thank you also for anchoring our discussion in the very present pandemic context. What is the perspective concerning the EU Charter for the next decade, Director O'Flaherty, in your view?
Thank you. In 10 years' time, the Charter will be 30 years old. When the European Convention on Human Rights was 30 years old back in 1983, it was transforming our societies. I grew up in Ireland. I was a law student back then, and I saw how decision by decision, my society was being transformed through the power of that instrument. I have no less an expectation for the Charter.
Thank you. Wow. Okay, now the same question about the perspective for the next 10 years for the Charter to President Lenaerts.
Well, I can absolutely fall in line with what was said by Věra Jourová and Michael O'Flaherty. I am very optimistic in the role of the Charter as a consolidation of fundamental rights protection in Europe, not just at EU level, organically speaking, but within the member states. And strangely enough, I take courage from that critical comment of this judge who finds a charter complicated. First of all, the colleague discovered the existence of the charter, and he is intrigued by the question, do I understand this? Well, he will next time around ask preliminary questions on the interpretation of the charter to the Court of Justice. And what we see is this increasing number of cases in which national judges ask the court to interpret the charter, and this in the widest range of charter rights, not limited to only a few of them, but the widest range. That development over the next 10 years will lead us exactly to the point described by Director O'Flaherty. It will transform societies, the judicial decisions on the Charter being triggers for the political process to take it from there. And I think it's this interaction between the judicial process and the political process, whereby the political process gets sort of to operate as a knock-on effect to the judicial process. That is what we are now seeing in the field of the enforcement of the Charter.
Thank you. And last but not least, off to Minister van Dunem. What is the perspective on the EU Charter for the next 10 years?
The
future of the Charter for the next 10 years lies in our own hands, the hands of the European citizens, the hands of the European institution, in the hands of the European governments. We should take co-ownership of the Charter, a Charter co-owned by the European institutions, countries and citizens. If we can do this, if we continue working like we have been working so far, in partnership with the Commission, the Council, the FRA, with all the Member States, pushing forward to implement the Charter on a daily basis, disseminating the Charter, I do believe that in 10 years, the Charter will have been implemented in our countries as a living reality, not as a document underused and then under knowledge. Let's work together. Let's work for the benefit of all, for the dignity and equality of all European Union citizens. Let's give this example to the world. The Charter will be our guide.
Thank you for this motivating final words. And so here we have reached the end of this absorbing and constructive conference. Big thank you to our great panelists, Věra Jourová, Michael O'Flaherty, Koen Lenaerts, and Francisca von Dunem. Thank you to all our guests too. For all registered participants, I'd like to also remind you about the follow-up session at 11:45 at WebEx. During the session, FRA colleagues will present hands-on on the agency's latest developments on the Charter, namely the new Charter guidance device for the first time. But now, let me wish you all a great day and fundamental rights better protected. Thank you and goodbye.
Improve law and policies by always checking the applicability of the Charter. You can do that via easy-to-use tools, for instance those developed by the European Union Agency for Fundamental Rights. The Charter Handbook tells you when and how to apply the Charter. And online, the Charterpedia provides a vast amount of Charter-relevant information. The Charter helps you to make indivisible rights visible, rules more relevant, people the priority. Apply the Charter, deliver our rights.